Hi everyone, in this video we'll try and understand the differential treatment of compound financial instruments under the Indian Accounting Standards and the Insolvency and Bankruptcy Code 2016. We'll also understand the reasons for these differential treatments and whether the differential treatments are justified. So what is the basic understanding that we need to proceed? First, we need to understand what are financial instruments. So a comprehensive understanding is something that we'll get only after reading IND AS 32. But for the purposes of our discussion today, if we understand financial instruments at a basic level, it would suffice. So financial instruments are nothing but a contract that creates financial asset for one party and a financial liability or an equity for another party. So what are financial assets and financial liabilities? Now, these are very complicated definitions, but for our discussion today, we can say that if there is a contractual right to receive cash, or there is a contractual right to receive equity instruments of another entity or another financial asset, then we say that it's a financial asset. And for financial liabilities, the same thing, but there would be a contractual obligation to settle with cash or equity instruments that do not meet the fixed to fixed criteria. So this is the basic understanding that we need for our discussion today. What are compound financial instruments now? Now this is only relevant for the issuer and not the holder of the instrument. For the issuer, if at the same time in one particular instrument a financial liability as well as an equity component is being created, then we say that it is a compound financial instrument. Why is it called compound? It can also be called as a hybrid instrument. Why? Because it has both financial liability and equity components for the issuer. And this is where the problem comes, because under IBC, you have to decide that whether you would want to treat this compound financial instrument as an equity or whether you would want to treat it as a debt. Because if you treat it as a debt, then the holder of that instrument would become a financial creditor and then will be able to file for for the CIRP process. And therefore this classification under IBC will become very important. So why is this discussion important today? If I look at all the stakeholders, for an investor, it is very important to understand that the instrument that I am holding, what is the relevant position of that instrument with regards to its waterfall mechanism at the time of liquidation. Because if I am getting classified as an equity, then the expected rate of return that I would be expecting from that instrument would be higher as compared to if that instrument was being classified as a debt. For auditors, this would be relevant with regards to the impairment testings that they would do, and also the SPPI test. Now this SPPI test is not relevant for understanding today, but as per IND AS 109, a financial asset can be accounted as per the amortized cost method only if it is meeting two criteria, that is, that instrument is meeting the SPPI test, that is solely for principal and interest repayment, and the business model is hold only. So whether a preference share in any form, suppose if it is for our discussion today it is cumulative redeemable preference share, whether this instrument in any manifestation can this instrument be treated to be held only for the payment of principal and interest. That would be very important to identify, because theoretically it is possible as per IND AS, but after discussing this relevant case law, would we want to say that SPPI test will be met? That is an important discussion that we would want to have today. For companies, it will of course impact the way they are able to source their funds. So what is the discussion that we are having today? So there is a judgment dated 26th August 23 in the matter of EPC Constructions India Limited and Messrs. Matix Fertilizers and Chemicals Limited, where EPC filed an application under section 7 of the IBC as a financial creditor. From now on, I want to refer it as a petitioner, and for Matix, I'll use the word respondent. So we'll understand the basic case law on as in the facts of the case, and then we look at the arguments that have been made by both the parties. So the respondent, that is Matix, wanted to build a greenfield fertilizer complex and approached EPC, that is the petitioner, in this regard. They both entered into an EPC contract. The total value of the contract was 3,200 crores. This contract had to be completed by 2013. The reality is that this contract could not be completed and there was a significant delay, on account of which the disputes started to come, and it was decided that there would be an additional cost that would be required to complete this project. And for that, the entity, that is Matix, will have to borrow money. So it was decided to convert the amount which was payable under the EPC contract on August 26, 2015 by the respondent to the petitioner into redeemable preference shares, compulsory redeemable preference shares, which where the interest would be cumulative. So what were the terms of the issue? The term of the issue was, first of course, the date of the issue, which was 26 August 2015. The face value was 250 crores. The interest was 8%. The term was 3 years. The total interest which was cumulative was 60 crores, 20 crores every year. And the redemption value would be 310 crores, which would be redeemed on 26 August 2018. So why was this transformation of this issue of this instrument needed? Because there was an additional amount of money that had to be raised so that the fertilizer plant could be completed, and they needed to meet the debt equity requirements. Therefore, if they raised an equity of 250 crores, keeping in mind a debt equity ratio of 2:1, they would be able to raise 500 crores of debt. Now, this is in August 2015. It is very important to know that had this instrument been issued after the implementation of Indian accounting standards, then this entire instrument, or at least majority part of this instrument, being an obligation to pay in cash, would be classified as a financial liability. But as per the earlier IGAP, it was classified as equity, and therefore this debt equity ratio component was met. So now this is the fact of the case. Now, on 26th August 2018, this instrument was not redeemed, and therefore the EPC Construction decided to file a petition before the Honorable NCLT as a financial creditor for the application as in the CIRP process. So we look at the arguments that have been made by the petitioner, and then we look at the arguments that have been made by the respondent. So what is the first argument that the petitioner is making? Now the petitioner is saying that I am, or the money that I have given is satisfying the conditions that have been mentioned in section 5(8)(f). So let us look at these conditions and then see whether the conditions are being satisfied or not. So section 5 clause 8 says that a financial debt means a debt along with interest, if any, which is disbursed against the considerations for time value of money. Now, what is a debt exactly? Debt is a liability or an obligation in respect of a claim which is due from a person and includes a financial debt and an operational debt. Now, keep in mind that this is an operational debt because the money that was payable was in the nature of an EPC contract, which was for the provision of goods and services, and therefore would come under the application of operational debt. So it is very important to say that the debt that is here, if that can also be an operational debt, if it is disbursed for a consideration of time value of money. That means from August 2015, this was the claim that is being made by the petitioner, is that although it is in the nature of operational debt originally, but from August 2015 it was disbursed for the consideration of time value money, which is the 8% that we have seen, and that is the instrument that that has been subjected to default. So therefore they are saying that, okay, because of this, now I am meeting the condition. Now another important question is that the word disbursed is used. So should this be a physical transfer of money, or can this be symbolic as well? Because as on August 2015, I am not transferring 250 crores. It's just that the nature of 250 crores is changing its form from, say, a receivable in the nature of an EPC contract to a investment in that particular company in the preference shares. So would that be acceptable? So the claim that they are making is that if you look at the clause F, they say that any amount raised under any other transaction, including any forward sale and purchase agreement having the commercial effect of borrowing. So the claim that is being made by the petitioner is that this is an arrangement that has a commercial effect of a borrowing and therefore would come under the ambit of this definition. So this is the claim, and we'll evaluate the merits of it later on and what the observations of the tribunal was. What is the second argument that they're making? That now that I have established myself as the holder of a financial debt, now I want to establish that a default has taken place. So then they say, okay, what are the conditions of default? So default means non-payment of debt when whole or any part of the debt has become due and payable and has not been paid by the debtor or the corporate debtor, as the case may be. Now, the claim that is being made here is that the instrument had become due to be redeemed in 2018 and that instrument has not been redeemed, and therefore there is a default under section 312. So this is the case that is being made by the petitioner. They are relying on certain judgments. Unfortunately, this judgment, which is the HDFC Ventures Trustee Company Limited versus Kakari Estate Developers, this is not relevant. Why is it not relevant? Because in this particular case, although the judgment did say that the preference shareholders in this particular case would be treated as financial debt, but it said that it would be treated as financial debt only with regards to the promoters of the corporate debtor and not the corporate debtor directly. It was only after a subsequent arrangement or a compromise agreement where the tribunal ruled that, okay, after this compromise agreement, we would hold that the corporate debtor will, the instrument would become a financial debt with respect to corporate debtor as well. But there are no such considerations or no such guarantees in this particular example, and therefore referencing this particular case is not really applicable to the facts and circumstances of this particular case. So now what is more important is that the petitioner wanted to establish that the code should be looked at in isolation and it is a complete code. Why was the petitioner saying that it should not, I mean, the provisions of the Companies Act should not be considered, or we should not go out of the IBC to look at this instrument? You'll understand later on. But this is the you can say a petition or a prayer that is being made here, that you should not go out of the IBC, and therefore they cite the relevant case laws where the Supreme Court has also adjudicated that the IBC is a complete code and is exhaustive. Now, another claim that is being made by the petitioner is that as per the provisions of Indian Accounting Standards 32, this amount or this instrument has been classified as a financial liability in the books of the corporate debtor. And if it is being classified as a financial liability in the books of the corporate debtor, then the holder of that instrument would be classified as a financial creditor. And therefore, they are trying to corroborate their claims basis the financial statements of the respondent. So this is one claim that is being made. Now, why is IND AS 32 relevant? They have given the provisions from section 128 to 134. Specifically, I'll talk about section 133, where the Companies Act says that as per this section, the relevant accounting standards have to be followed, and it must it must be ensured that the following these relevant accounting standards, a true and fair picture of the state of affairs of the company are being reflected. So the claim that is being made by the petitioner is that if you look at the combined reading of the Companies Act and the Indian Accounting Standards 32, and as well as the books that have been maintained by the corporate debtor or the respondent, then the conclusion that we can draw safely is that the substance of this transaction is that of a financial liability that has been recorded in the books of accounts of the respondent. And as per section 55 is concerned, section 55 of the Companies Act, it says that the preference shares can be redeemed either out of the profits of the company or out of the proceeds of the fresh issue of shares. And therefore, the claim that is being made by the petitioner is that this is not a condition for redemption. It is just a mode of redemption, which means that it is, I mean, even without complying these two provisions, there would still be a default under section 3 clause 12. So this is the general argument that is being made by the petitioner, And on the basis of this argument, they say that we have a case under section 7 of the IBC. Now, what are the arguments that have been proposed by the respondent? Now, there are three layers of defense that the respondent has taken. In the first layer of defense, the respondent has said that, okay, this particular instrument should not be classified as a debt in the first place. They should be treated as equity shareholders. In the second line of defense, they have said that, okay, fine, if you don't agree with me that they should be treated as equity shareholders, they should definitely not be treated as financial creditors. They may be operational creditors if at all, because the original nature of this transaction is an operational liability, and therefore a person who is a holder of an operational liability cannot become a financial liability. So that is the second line of defense that they're taking. The third line of defense that they're taking is that, okay, fine, even if you say that they are, for a second, even if I assume that they are financial creditors, there is no default under section 312, because the conditions of section 55 have not been met. And this is not a mode of redemption, but a condition of redemption. So there is a three-step or three-level of defense that the respondent has put. Now, the tribunal looked at the first and read it with the third line of defense and said that section 55 is actually talking about the condition of redemption, and therefore, unless and until the provisions of section 55 are not met, the holder of the cumulative redeemable preference shares will not step into the shoes of a financial creditor, and therefore the first condition, the first line of defense will hold true, and the holder will be treated as an equity shareholder. And to substantiate their claims, section 284, 255, which provides a definition for members and definition for a share, which also includes preference shares of the Companies Act, has been taken. Now, this is the precise reason why the prayer was of the petitioner that the IBC is a complete code and there is no need to go to section 284 or to clause 55 or other such sections 55, for example, of the Companies Act to understand and interpret the position of a particular instrument in the context of the IBC. But the tribunal adjudicated that no, a comprehensive understanding of the instrument is needed so that we can establish whether that instrument would fit under section 58F or not. And this in substance would affect the rights and obligations of the holder of the instrument as well as the issuer, and therefore it is important to take a comprehensive view of this particular instrument. And therefore, after analyzing all these things, the tribunal adjudicated that the preference shareholder would not be considered as a financial creditor unless and until the conditions have been met. The conditions in section 55. Now there is an important section 47 that I would want to discuss here. Section 47 says that if the dividends have not been paid for a continuous period of 2 years or more, then in that case the holder of the preference shares will have a right to vote. Now this is very important because you have exercised your right to vote in the past 2 years, and now you are claiming yourself to be a financial creditor. So therefore, your exercising the right to vote further weakens your position as a financial creditor. So all of these observations were made by the Honorable NCLT to conclude that the holder of the preference share would not be considered as a financial creditor. Now, when you look at this entire discussion, you realize that, okay, where is the conflict here? The conflict is that if you look at the Indian accounting standards, the Indian accounting standards would account this instrument in a different way. The Indian accounting standard would say that, okay, there is an obligation that I have to pay 310 crores after 3 years. Now, if I look at this instrument and I say that, okay, the market rate of interest had the company borrowed 250 crores as on August 2015, it would be 15%. So the present value of this liability would be, suppose 203 crores. What is the amount of liability that I'm settling? 264 crores as per Matix, for example. So what the Indian accounting standards would say is that you record the present value of the future obligations, which is 310 crores, as per the market interest rates, which comes to 203 crores, as a financial liability. and the balance component of 60 crores 71 lakhs you record it as an equity component of CFI. So the Ind AS is assuming that the risks that I'm undertaking as per section 51, the risks that I'm the right to vote that I've got under the Companies Act, all of those rights, there is a consideration that I have paid which is 60 crores 71 lakhs, and the consideration that I am paying for the liability is 203 crores, and therefore there is a differential accounting treatment that is being given to this compound financial instrument, and that is the precise reason why it is called a compound financial instrument. Now, this is one accounting that is being done. So which interpretation is correct? Differentiating the financial liability component and the equity component, or looking at this entire instrument as an equity instrument? Now, here I would want to talk about this aspect, that Indian accounting standard looks at this instrument as from a conservative perspective, because we are accounting it in the books of the issuer as a compound financial instrument. So for the issuer, suppose if the issuer comes and tells me as the auditor that in the coming 3 years I would not be making profits, and therefore I would not have the obligation to pay 310 crores as per section 55 of the Companies Act, then this instrument should be classified as an equity instrument and not as a financial liability. So this claim could not be admitted because the entity does not have an unconditional right to defer the settlement of this instrument. Because what if the entity makes profit, right? So since there is no unconditional right to defer the settlement, this instrument will be classified as a financial liability in the books of the issuer. Now, just because Ind AS is taking a conservative approach in accounting, that does not mean, or that does not imply that a petitioner can take an optimistic approach. So just because the entity does not have an unconditional right to defer the settlement, the same way the petitioner does not have an unconditional right to demand the settlement unless and until section 55 provisions have not been met, and therefore the claim of the petitioner under section 7 was not maintainable. Now there are other aspects also that the tribunal considers when looking at these instruments. Now the tribunal applies a concept of what I would want to call as the principle of equitable subordination, where even as per Indian accounting standard, if a particular transaction is being considered as a financial liability, for example, if there are related party loans or promoter loans, now Indian accounting standards would want to look at it as a financial liability if there is an obligation on the entity. But with regards to law, these transactions can be equitably subordinated even below the claims of the operational creditors, if these particular related parties have a significant role to play in the position of insolvency or for triggering the insolvency of that particular corporate debtor. So therefore, the approach of Ind AS is different, is for the accounting purposes, and it can only help in substantiating the substance of the transaction. But as far as the treatment of that particular transaction will be considered, the principles of equitable subordination will come in, and an all stakeholder approach would be relevant. For example, when we are accounting a particular transaction as per the Indian accounting standards, we do not look at other transactions. For example, if an entity has issued a compound financial instrument, now it doesn't matter if the entity has issued plain vanilla bonds to some other stakeholder when accounting as per Ind AS is concerned. But when the treatment to be meted out as per the IBC will be considered, the tribunal will sit and contemplate whether I should be treating an holder of a plain vanilla bond at par with the holder of a compound financial instrument with regards to the liquidation mechanism. Would it be fair, just and reasonable to hold these two holders at the same pedestal? So these are important questions that the tribunal will address before it classifies a particular instrument holder as a financial creditor or as an equity shareholder. So a combined understanding of these provisions give us an understanding that the differential treatment that is being meted out would be under these particular considerations that I have just discussed, and these considerations do make the differential treatment justified. Thank you very much.